Can you appeal a DUI conviction? That's what I'm going to cover in this video. I'm Dan Joffe, DUI lawyer at Next Law. You can appeal your impaired driving over 80 or refusal to take a breathalyzer conviction, but there are strict rules regarding the appeal process. Here are 5 things you need to know about appealing your DUI conviction. 1. What can you appeal? You can appeal your DUI conviction if you believe you are innocent. You can appeal your DUI sentence if you believe it was too harsh. And you can appeal your DUI conviction if you believe the judge made a mistake. 2. What is the timeline for appeal? You need to file a notice of appeal within 30 days of your sentence. If you are past this 30-day time window, you must file a form called the application for extension of time to appeal. 3. What happens to your sentence or license suspension during the appeal process? It is possible to stop the original sentence before your appeal is heard, but this is not automatic and is not guaranteed. You would need to file documentation that is different from the appeal documentation to stop the sentence or get your license reinstated before your appeal is heard. 4. Will the same judge hear your appeal? No. Your appeal would be heard by a different judge, and the judge that will hear your appeal will not discuss your appeal with the first judge that convicted you. 5. You can only appeal on mistake in law. For clients, one of the biggest misunderstandings about appeals is this. You can only appeal based on a mistake in law, not on fact. Here's an example of what that means. Let's say you were convicted of an impaired driving charge based on a blood alcohol reading of 160, but you believe you were innocent. On an appeal, that 160 reading is a fact. You can't challenge it. But you can attack the 160 reading by claiming that there was a mistake in law in allowing that 160 reading to be entered into evidence. For example, if at your appeal it is determined your constitutional rights were violated on your arrest, your 160 reading would not be admissible into evidence and you are likely to have your conviction overturned. If you've been charged with drunk driving, DUI, impaired driving, or refusing a breathalyzer test, your legal strategy can make the difference between winning and losing. Reach out, let's have a confidential discussion about your case. The call is free and you can book a time by clicking on the link in the description below.